8:05 right now. Savannah, thank you. A bond amount that could be the new norm in North Carolina. This morning, a Charlotte teen accused in a series of shootings into homes is now in jail on a $5.3 million bond. Officers first arrested Dai'Quan Mills last month for a shooting on Redwood Drive. He was also charged for a second shooting while in custody.
Investigators say that's on top of 2 other prior arrests that Mills had for other charges. He's currently accused of crimes ranging from damage to property to shooting into an occupied dwelling. Now experts say that this could be in part due to the fatal stabbing of Irina Zarutska on the light rail this summer, which sparked national attention. The statewide anti-crime bill dubbed Irina's Law went into effect on Monday.
Our chief legal analyst, Conley Rhodes, is joining us here. So when you see $5.3 million in terms of bond, that's a shocking number to some people. Where is bond normally set for something like this, and how may the law impact this?
Well, the best part about our statute in North Carolina is there is no normal part of what bonds should be set at. When I first took over as the chief magistrate in Mecklenburg County, on the wall for each individual charge, there was an itemized amount. Right. Assault on a female, $25,000. You know, some type of robbery charge, $100,000. It didn't take into account, you know, your history. It didn't take into account the actual weight of the evidence, the nature of the charge. It just said this charge, this amount. Don't do any thinking, hit the button and go. Well, the problem with that is our statute requires just a little bit more than that. It requires an actual assessment of a person's prior history, an assessment of their ability to come to court, their ability to commit a crime, specifically a new violent crime. And when you're making that determination, even at the magistrate level, you have to make it on an individual assessment. And so there is no normal range. But what I can tell you is this is outside of any typical range, any type of range that I've seen in the past. These are type of numbers that you normally would see with homicide cases, not with shooting in an occupied dwelling. But I mean, I'd have to see this entire package to know why. You know, I recognize the CMPD put out a number of times this person is a repeat offender, that he'd been out and was charged with multiple offenses. So I'd have to know, well, was he out on pretrial at the time of the offense? That's something that will go into consideration for me to say what type of conditions I'm going to set. I'd want to know, you know, how long in between those times. I want to know, has he ever missed court? Has he appeared? Have those other cases been dismissed? There are going to be a number of things that I'm thinking about before I make a determination. But 5.3, yes, it's an eye-popping type of number, more for a dramatic effect. And at the end of the day, if you don't have $20,000, you ain't got $5.3 million, you're not getting out regardless. So the number is really something that's to set aside.
Well, could this number be sending a message, Khalif? I mean, CMPD has said these repeat young offenders are endangering the community. So does this lead to tougher charges, programs in the future to stop young repeat offenders? Well,
I mean, if they were looking at the news and looking at the reports, then yes. I mean, if we have a deterrent system within our criminal justice system, it's supposed to be both rehabilitative and deterrent, but it requires that people are participating in the system and aware of the things that are happening. And so, yes, you and I, because we're on the news, and people that are watching, guess what? They see that. People that look online, they see it. But for most folks, an 18-year-old isn't going to know that, hey, this kid just got a $5.3 million, so I'm not going to do that crime. The deterrent is not there. And you shouldn't be swayed as a judicial official by the tide of the day. You should have a determination to look at the person that's in front of you on a case-by-case basis. And so while I understand and appreciate that it's a heightened response to anything that's happening now based on what happened on the train, the horrific events that happened here in Charlotte that got national attention, make no mistake about it, I think this is an overreach in terms of what typically could happen. Back to Julian's original question, something like this you may see if he had 15 or 14 charges. Okay, $100,000 each charge, you know, something like that would be typical, and that would be sending a message. But since this occurred, you've seen an increase in these type of bond setting amounts.
And people might be confused about this. I'm one of them. When I see a horrific crime, a crime against a child, murder, things like that, we see a bond amount, and I've never seen a $5 million bond for crimes like that. Yeah. Not to say that shooting into an occupied dwelling is not a serious crime, but how do you explain such a difference in those bond amounts when it doesn't really seem to match the crime, or does it?
I got a couple of things for that, and I mean, this is a very serious crime. I mean, think about it. When you shoot a gun, if someone's in that house, someone could die. That could very well turn into a homicide. So that's the first part that I would say. But then I'd also say that every case is different and every judge is different. And so because they're independent judicial officials, one judge may listen to these facts and hear everything that the prosecutor and the public defender says when they're representing this person and say, You know what? $20,000 bond. The next day, a different judge can hear it and say $5.3 million. That's the part that is unique and great about our judicial system, that every judge brings their own unique experience to the table and can listen and hear the facts on their own. But what I can tell you is North Carolina has, in statutory language, a couple of things in place. First of all, you are required to set a condition for release for every case except for homicides in North Carolina, capital offenses. So if you don't set a bond, now you're in violation of our statute. So the DA's office can do something called a rebuttable presumption and say, you know what, there's no condition you can set, Your Honor, and that argument can be made, and it wasn't made here because a bond was set. So then the judge is saying, well, do I want to release this person or do I want to detain this person? I want to detain them, but the statute doesn't allow me, so then I set this high number that I know they can't pay, and that's how we get here.
Again, our chief legal analyst, Khalif Rhodes, weighing in on that for us. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.